Thank you for joining us. My name is Frank Musica, and I will be guiding you through this webinar. We will be looking at some basic ways a design firm can understand the exposures it faces and internally develop the firm culture and the individual skill sets to address those challenges. We will not get into much detail, so I urge all policyholders to access our School of Risk Management website, www.schneider.com/School of Risk Management, to download more substantive information about these topics. But first, let's talk about how design professionals are viewed by the law. Back in 1978, the National Society of Professional Engineers lost a Supreme Court case. The Society, NSPE, enforced an ethical rule that was a membership obligation. The rule stated that a professional engineer in private practice could not provide services based on fee alone. The situation was an engineer in a competitive bidding situation, and according to the NSPE Canon of Ethics, offering services on a competitive bidding basis corrupted the ability of the professional engineer to provide an appropriate level of service that allowed the PE to protect public health and safety, since doing so was the sole reason that professional engineers were licensed by the state. In NSPE versus the United States, the court ruled that NSPE's Canon of Ethics, which prohibited its members from submitting competitive bids to obtain contracts, was illegal. It was a restraint of trade. At that time, antitrust laws were being applied to all types of entities in the service industries. Now, NSPE lost the case, and with the loss, the industry changed. Things like offering services on a low bid basis, supplanting or enticing a client to work with another professional to change providers, and advertising based on anything other than a fraudulent statement became possible. But one important victory did come out of the case. That was a victory not only for the National Society of Professional Engineers, but for engineers in general. For the first time, the court recognized engineering as a learned profession. That was an important statement by the court. Historically, the learned professions were law, medicine, and theology. But with the ruling, engineers, and by extension, architects and others in the design communities, were recognized not as mere vendors of services, but as true professionals. So this is what the court and others have said about the professions. It is important because in this day where everyone from real estate sales agents to nail salon employees call themselves professionals, there are some basic rules of what it takes to be considered a profession by the legal system. It is not that an industry is licensed by the state. That is only a secondary recognition, but rather that the group of practitioners have these three characteristics. The recognized knowledge base is founded on both a common education and a shared experience. It is that body of knowledge built on research and developed by application, and it is constantly evolving. The knowledge base is always advancing, and with it there is a continual change in the standard of care for professional services. That is what the exercise of judgment, skill, and care means. A true professional taps this body of knowledge on every project and uses education and experience to perform services. Courts routinely recognize that there is no one answer at which all professionals arrive when providing a professional service. There is a scope of reasonableness that is created by the profession. And part of this is the extensive continuing education that is necessary to keep a profession moving forward, changing the abilities, expectations, and legal responsibilities of the parties. We think that this course and our other risk management offerings are part of that extensive continuing education because they will help professionals carry out their ethical and license duties and facilitate that service. I mentioned that licensure is not a defining characteristic of a profession. You might know that around the country, licensing laws, those that make an engineer a professional engineer or an architect a registered architect, are being challenged in state legislatures as existing only to protect the professions and not the public. The argument is that, therefore, such laws do nothing other than drive up the cost by stifling competition. All 56 U.S. jurisdictions regulate the professions, but even if licensing laws ended tomorrow, there would still be a legal distinction between those individuals who provide professional services and vendors who sell solutions. And in the profession, it is important to develop the capacity to manage risk because professionals and their firms should be creative and innovative in what they do. Otherwise, a computer program could replace professional judgment and skill. Perhaps we are moving to the use of artificial intelligence for many of the design and planning services. At one time, it was considered unethical for an engineer to use a computer program unless the engineer could produce the same result without the use of a computer program. I think we are beyond that, but society still relies on the creativity and innovation of design professionals. Consider these comments on preserving creativity and enabling innovation. Other than the established reputation of a firm, its creative assets, and therefore its greatest value, is the skills of those in the firm providing services. And if firms are to grow and prosper, they have to be innovative and not just providers of commodity services. That is the area of practice where artificial intelligence will take over. But when you are providing truly creative and responsive services, perhaps pushing that envelope or filling a need that others have not recognized, you face risks that are not easy to identify or calculate and perhaps difficult to ensure. So your ability to profit from these creative and innovative services will depend in large part on your firm developing your capacity to manage these exposures. Every treatise on risk management will point out options such as these. They're basic risk management strategies. Some are obvious, the avoidance and retention, and others more specialized, transferring some of the risk through the purchase of insurance, for example. But others take skill and can be most effective in managing risk. Many firms, intentionally or perhaps unintentionally, simply retain the risk and push on with the project. The exposures might be contractual rather than professional. And if firms that do not have the capacity to evaluate their contractual exposures might find that their future is bleak, not profitable, or even viable. So it is important that the decision to retain risk is made with an understanding of what risks are present for a project type, a client type, or a contract provision. Now that the economy is stronger, some firms avoid risk. They decide not to do a certain project type or not to work for a certain client who has a bad reputation in the industry or who has no experience in putting a project in place. Most firms, however, have the capacity to understand exposures and a will to manage them, and they might, for example, mitigate the probability of an unfavorable outcome by increasing their project-specific skill set, either through in-house training or subcontracting for expertise. Firms also need to understand how they can allocate exposures on a project. This can be done through forcing the client to retain the risk by using a limitation of liability provision, which shifts risk from the design firm to the client, or a waiver of consequential damages provision, or even indemnification provisions such as those that protect the firm from specific exposures such as related to hazardous waste discovered on the site or to third-party claims related to allegations of negligent design. And as mentioned, transferring risk should be understood as a way to manage risk. That is why firms buy professional liability insurance, cyber liability coverage, and many other insurance products. Those policies all accept the transfer of some of the firm's risks. So let's talk about developing the capacity to manage risk, because doing so, developing capacity, creates a corporate culture. It does not matter if the firm has procedures in place, such as quality controls or documentation system, unless the firm has the management of its enterprise risk as a corporate culture. Why develop the capacity to manage risk? If you are a design professional, you have many vectors of varying magnitude and direction influencing your firm and your future. A basic part of corporate culture is the careful nourishment and protection of a firm's reputation. It is a firm's greatest asset, and if a firm finds its reputation tarnished, perhaps the firm is mentioned in a news report of a project deficiency, that firm might lose clients or, at the minimum, find its negotiating power reduced. And remember that registration laws exist to protect public health and safety. By managing your risk, you enable your firm to meet that requirement. What you do and how you do it affects not only your client, but all stakeholders in the project, and that includes future users. And as I stated, for firms to prosper, they have to be innovative and not just provide commodity services. By developing your capacity to understand and to manage your risk, you are facilitating a firm's path to innovation. Whether it is new services, new deliverables, or just new designs, innovation is difficult if you have to spend your time and money making up for past business or professional mistakes. And in conjunction with protecting your reputation, you have to meet the expectations of your client. A dissatisfied client is one who does not pay the fees for services and who brings claims, usually not because of a technical design problem, but rather because of disappointment. And of course, public expectations must be satisfied if your reputation is going to be protected or enhanced. So by developing your capacity to address the perils of practice, your firm is not only better positioned to manage your cash flow and project profitability, but also to create a firm that is a good place to work, that provides that reward of accomplishment and value that design firms and their employees seek. And as you are in practice, you realize that a major key to managing risk is to manage client expectations. Most professional liability insurance claims are brought by clients and often are generated by unrealistic expectations rather than professional design deficiencies. So when we work with our focus groups or committees from the professions, this is what they tell us that successful firms do. You do not overpromise by your enthusiasm for the client or the project. Rather, you underpromise, which makes delivering more than expected possible. You do not promise an on-time and on-budget project when you have no control over either attribute, but rather you work with the client on reasonable expectations. Working with the client, you set common goals and expectations, ones that are reasonable given the budget, the contractor selection method, and the many external factors that will have a varying degree of influence on the success of the project. And that means clarity in the decision-making process, in the specific requirements for communication on the project development and completion, and in what is not going to be included in the scope of service. Every project is a coming together of highly dissimilar entities, and it is critical that right up front, the roles and responsibilities are clearly defined and documented. And every project has some barriers to success. Those should be recognized as much as possible, and project clients should give their informed consent to going ahead with the project or incorporating certain elements in the project. For instance, a project with an anticipated cost today might be affected by higher prices caused by labor shortages or material price increases because of tariffs or lack of availability. These barriers to the financial success of a project should be recognized in the planning process. In taking these steps, you and your client, and possibly other stakeholders, are really establishing common measures of what will make the project successful. Whether it is meeting budget constraints or achieving a timely delivery or gaining attention and prominence in the marketplace, the real goals and measures of success should be jointly established and recognized. And basic to developing the capacity to manage risk is to understand that your marketing information, whether it is through personal contact, website information, or generic advertising, can be problematic. This is why we've had so many disputes during the early period of designing for sustainability. It wasn't an issue of raising the standard of care, although programs like LEED did that, but rather of firms misleading themselves and their clients. Remember that disappointed expectations lead to claims, and clients often are dissatisfied with the professional services a firm provides because the services did not live up to the marketing. It is another case of overpromising and therefore setting the stage for under-delivering. And it's not just disappointment. Marketing can lead to actual detrimental reliance, and often that reliance is based on what a court might interpret as establishing an express warranty of service as a result. So your capacity to manage your risk includes your ability to develop an effective but authentic marketing message. Obviously, some of what you show or tell a prospective client would be considered in legal terms as puffing or mere puffery. So perhaps telling a sophisticated client that your firm is the best in the area for a specific project type might not lead to the allegation of fraud in the inducement and that legal argument of detrimental reliance on a statement or a promise. But the same statement made to a client who does not understand the specific issues with design leading to construction, the unsophisticated client, could be held to be actionable. The same statement, because it was made to a different party, might result in a major risk to the firm's financial operations. Remember that there are more than just professional liability claims. Misrepresentation, fraud, deceptive practices, and breach of warranty could all develop out of an improper marketing effort. Now some basic procedures. And let me mention that a firm can have design procedures in place and detailed quality control or quality assurance methodologies and extensive communication and documentation systems set up. But if they are not used or not properly used, they will only be trapped once a claim is filed. What is the most important aspect of a design professional's relationship with the client? Obviously, it is the appropriate level of communications with the appropriate people in the client's organization. If there is one significant failing of most design professionals, it is their lack of ability to clearly and consistently communicate with their clients. Remember, if you are providing professional services, you're making recommendations and your client makes decisions. Your ability to step into the client roles and make decisions the client should be making can lead to legal difficulties, including your being identified as a fiduciary of the client, and thus having to meet an entirely different level of legal responsibility than you are trained to accept. Just as with medical professionals, the client, the patient, has to be able to give informed consent. So your communications about a project and your services have to address those three big issues of project cost, project time, and project quality. When you communicate with your client or others, you must have a system in place. It is also important that as you communicate, you document that communication in a timely manner. If your documentation is not contemporaneous, it might not matter. It would not be admissible in court. It would be considered hearsay. So these are three things you have to keep in mind to set up and follow a system of communications and documentation for each project. You will have company-wide procedures, but remember, each project might require a different level or different process or a different group of people with whom you need to communicate. And as I mentioned, you have to record facts in a timely manner. That cell phone call needs to be recorded as soon as you get off the call and not a week later. Those meeting minutes have to be current. And that site visit report should be entered as you are performing your services or at least immediately thereafter. And always act as a professional. Do not defame the contractor or a sub in your report. Do not treat communications as private when in fact they can all be made public. And certainly don't record something such as, well, that design detail might work this time, but we should never use it again. We can discuss some of the documentation challenges. Many can be because of verbal communications. Remember to document telephone conversations. If you do not, and a disagreement arises, at best you have a weak argument as to what was said, and at worst, the other party documented it in a way that you cannot challenge. Make sure that what you negotiated ends up in a contract for your services. No side conversations or promises or statements from a client that say, don't worry, we won't hold you to that onerous contractual commitment because it is just necessary boilerplate our attorneys put in. The language in the four corners of the contract matters. When a court attempts to resolve a contract or an arbitrator replaces the adjudicative function of a court, it usually only looks at the final contract, and because design professionals are considered sophisticated, considers the contract language as negotiated and freely accepted. And while on-site discussion probably will not be held to change your contract terms, careless voice communications can lead to client disappointment and even establish the basis for a warranty claim. We've had too many claims where someone on the site promised the owner that the project would finish on time or that everything will work properly. And increasingly, digital communications are taking over the sharing of information. We have published extensively on the use and sharing of digital information. For BIM information, there must be sharing protocols in place to make sure the parties involved know the purpose and limits on usage. With digital design information, we have not yet seen a case where the use of BIM is seen as necessary to meet the standard of care. But for the most part, you should expect that your services will be held to that standard. So please make sure if you are sharing information digitally that you have in place a protocol such as the AIA E203-2013, which is a building information modeling and digital data exhibit. Treat all texts and emails as public information. They will be discoverable in any dispute, and chances are, even without a dispute, the information might be shared inappropriately. Have controls in place on who can email what to whom. Emails and text may seem like casual communications, but they have a much greater impact than that. Treat them as if they were drafted, edited, and issued on letterhead. And photographs and drones create additional problems. Images of a client's project cannot be shared without proper authorization. For instance, we had a case where an intern at an architecture firm took a cell phone picture of a project model and shared it with friends. It eventually made its way into the public media, and since the picture showed a model that was being used to attract investments for the project to allow the developer to purchase the remaining land for the project, the violation of the developer's confidential information made it impossible for the developer to complete the land purchases, made the project no longer viable, and ended up with the developer claiming tremendous damages against the architecture firm. And that breach of confidentiality was not covered by professional liability insurance because it had nothing to do with negligence in the actual performance of professional services. Similarly with drone records, if you are taking drone shots legally, you might also be violating the privacy or confidentiality of surrounding sites. And if the owner or contractor is using a drone for site observations for whatever purpose they have, be aware that if they share that information, pictures or video stream with you, you might have an implied duty. So if you're not being paid to review drone information, don't look at it. Don't even accept it, because an inference might be drawn that you should have looked at it, and by doing so, have recognized anything from improper construction to safety violations. And do you keep drafts of contracts? That's a judgment call. As I said, usually a court will only look at the four corners of the document, at what the parties agreed to and put in writing. But there could be situations where a draft shows the client's limitation of your authority or other negotiation strategy information, such as a rejection of an environmentally sensitive design. Note that the fact that a provision is deleted from a contract is usually not evidence of an affirmative requirement. For instance, if a client deletes something listed in the contract draft as an optional, additional, or supplemental service, that deletion does not mean that the service is now part of basic services. And the deletion of a disclaimer does not automatically create a duty. Note that you should always document the design criteria and standards. And be aware that if you're looking at a new product or system, or even an unusual use of an existing product, you need to document your research and that allowed you to look at both the advantages to the client and any disadvantages or dangers, including the possible lack of availability of the product. And remember to document your providing of an analysis to the client and the client's conformed consent to the use of an untested product. Remember that most professional liability claims come from clients. Over 2/3 of all claims against design professionals come from their clients. So make sure your files are well documented as to important decisions by your client, such as in response to your advisory letters, the client approvals, and any authorization by the client to have you act on the client's behalf. A good example of proper documentation saved a design firm in a school HVAC failure situation. The architect was contacted by the school board's legal counsel and told that the system failed, and the attorney asked the architect, "What are you going to do to fix it?" That is a professional liability claim, in that there is an implied allegation of negligence and a demand for money or services. In this case, the architect went to his records and emailed the attorney a letter from the mechanical engineering firm advising against downgrading the system by the school board. The engineer stated that a downgrade did not violate code requirements, but was likely to increase maintenance costs and probably fail prematurely. And the architect documented in a file that the school board acknowledged the letter but decided to save on the initial system through a downgrade. When the attorney received the copy, the demand was no longer, "What are you going to do to fix it?" but rather, "How can you help us remedy the problem?" And keep in a project file all project-specific information prepared by you or your consultants or provided by others at your request or because of the contract documents. Remember with the photographs, only those that were specifically taken for a purpose, reviewed and recorded, should make it into the final documentation. There has to be a reason for each photograph. And it makes sense to document why the photograph was taken and how it was reviewed. And of course, if tests are required initially by contract or during a project because of a changed condition or the need for specific evidence, the information about the test and the results should be preserved in the project file. It is, of course, critical that communications and therefore documentation during the construction process follow the dictates of the contract documents. So communicate as required and document all communications. Note with the submittals, never review any submittal not required, and you are the one who sets the requirements. Do not let the contractor make you the contractor's quality control expert. So your documentation of a pseudo-submittal is that it was returned without any review or comment because it was not required by the contract documents. And submittal logs and managing the submittal process appropriately is one of the activities that can lead to a deductible credit if a claim occurs, or even discount in your premium. Managing that submittal process is that important. So follow the standard procedures as, for example, are clearly defined in the AIA's standard contracts or the Engineers Joint Contract Document Committee standard contracts. You know, the system of building in the United States is not the same as the system of manufacturing. So changes often occur during the course of construction, and change orders happen. And a contract document should have the procedures for change orders clearly stated. Since change orders often lead to client dissatisfaction and implicate the design professional in a way that generates the claim, it is vital that the process be well documented. And with site visit reports, many firms document the process during the process. But remember to document when you visited, the purpose for your visit, what work was in progress, and what was observed based on your duty. And keep your documentation objective. Often projects never close out properly, but the better the system and the greater the documentation, the more likely it is that you can deflect a professional liability allegation. Remember that a lot happens at substantial completion, including a change in who has an insurable risk on a project. Once you have everything in the file, do not simply ignore it. Right? That file should be cleaned up and kept either in its original form or image. Look at what statutes of repose applies to the project and preserve the project record at least for that long. And your contract might assign you responsibilities that require you to keep the information for a longer period. So make sure you comply with the contract obligations. But do not keep information forever. Your office should have a system in place not only to clean up the file when the project is complete so that you do not inadvertently keep inappropriate or unnecessary information, but also a file destruction policy. It is a basic part of any retention policy. Keep in mind, however, that if a dispute occurs, you cannot at that point purge the file. That would be considered spoliation of evidence. So if you get that letter on the condo you designed many years ago, 1 week before the statute of repose would cut off all possible claims, you must keep the records beyond your normal retention period. And make the official file the only file. Do not keep duplicate records. We often find that participants on a project keep home or side files. They can be devastating to a firm that otherwise treats documentation seriously and carefully. And as a reminder, systematic. Have the system in place to regularly document the project. Make sure you do not ignore your documentation procedures. Documentation has to be contemporaneously made and factual, right? You do not give opinions in a project file. When there is while there's a value in evaluating your procedures and assessing your design, commenting in the project file is not the place for any review. If you have some procedures that you think need to improve, in the old days, firms would look at statistically valid total quality improvement as a way to increase their quality. If you document things that way, send your analysis to your attorney so it can be considered privileged information. Do not simply put it in a file where it's discoverable. And let's talk ethics again, since in managing your risk, you also must have a sound ethical basis for your actions. Despite the 1978 NSPE case that caused the organization to rewrite its code, your state, your professional society, and even public expectations require you to practice in an ethical manner. But that can be used to your advantage when a client or lender or other party asks you for something that makes you cringe. For example, when that lender, that bank, asks you to certify something that you do not know to be factual, you can rely on the ethical constraints of your state registration law. Your registration law probably indicates that you cannot state as a fact something you do not know to be a fact, either from your education or your observation as part of your services on a project. It is unethical to mislead someone. So facing a requirement to provide an unqualified certification, essentially a guarantee of a fact or condition, rely on the demands of your profession and on your state registration law and refuse to lie. Either qualify the certification and make it a professional opinion based on what you know, or reject providing the certification. Let's talk about quality management. There's no one recipe for quality assurance or quality management programs. Every firm is different, with differing project types and clients and internal processes. Some firms use quality control, quality assurance manuals. Some issue policy and procedure bulletins, while others simply rely on verbal instructions. Regardless of the methodology, it is advisable to establish and reinforce the general standards by which a firm's employees is expected to perform. The adoption of quality control standards brings a measure uniformity to a firm's practice. The adoption also can be a demonstrative factor in establishing performance that meets the standard of care. Firms without any quality control standards or procedures are often left at a loss to explain why a particular employee or group within a firm missed something or failed to follow some set procedure. However, the adoption of a too detailed manual or list of procedures can have the opposite effect. The quality controls may, in fact, alter the applicable standard of care. Furthermore, once adopted, the failure to follow the standards and or procedures outlined in the manual can create a presumption that a firm or its employees' performance was negligent. Therefore, it is imperative to take care in adopting and using quality control standards that will meet the ongoing needs and realities of your firm. Remember, there's nothing worse than having a quality control or quality assurance program established and not following it. It destroys credibility immediately. So do not develop an elaborate quality control process that no one wants to follow. Your top leadership actually has to provide leadership on creating and using the system, and your firm's business principles should set the reason for what you do with a quality control, quality assurance program. And keep in mind that your system might work on most of your projects, but your client might have other demands that you must meet. These differences are usually set by your client in your contract. Remember, you're not required by law to produce a perfect design, okay? But you must meet the applicable standard of care, and having an internal process that allows appropriate reviews can be used to show that you understand the standard of care and strive to meet it. Your quality management plan should match your deliverables and their timely preparation with your contract obligations, and they can help you over-deliver to your client expectations. One activity we supported for years, and which is even built into the CNA policy as helping to qualify a firm for a deductible credit or reduced premium, is a peer review project. Many smaller firms have a sharing arrangement with non-competing but similar firms to review each other's processes and deliverables. Many larger firms have established systems of internal peer review procedures. Having an independent professional check on the deliverable before they leave the office can be extremely effective in mitigating the likelihood of professional liability claim. And again, it's an issue of meeting client expectations. And many firms are involved in constructability reviews, reviews of how a project could be constructed before the final construction documents are issued. Another way to tie the design process into the construction process. So we're going to use this webinar's polling feature to find out about your knowledge and use of these two types of reviews. Here's what we want you to do for both peer reviews and constructability reviews. There is a polling box, and we're going to give you a scale of 1 to 5, and you're going to comment on what your understanding of what constitutes a peer review and a constructability review. For project peer reviews, please select one of the options. Remember, this is about peer reviews on a specific project and not organization peer reviews that assess a firm's overall business and practice management operations. Okay, please vote. All right, and now let's do your assessment on your knowledge and use of constructability reviews, where you or the client has a contractor or subcontractor participate during the design process. Again, please vote. Okay, here are the results for the peer review. From this, it appears that about 2/3 of the voters state that they have suggested using or have actually been involved in a peer review. There's still about 10% or so who have never been involved. I think the percentage of firms using project peer reviews will be growing. In fact, with BIM, such reviews are much easier. There are standard contracts that can help you do this. And I think, again, from an insurance standpoint, it's very helpful in reducing your premium and reducing your deductible obligation. Here's what we have for the polling on constructability reviews. Much greater percentage, maybe close to 50%, have never been involved. A good number have had contractor input on design build projects. That probably is because the contractor is both leading the process and is a design firm's client for the project. And since the design builder has guaranteed a price, they want to know whether or not they can build a project in an efficient manner. And about 1/4 of the respondents say they either ask for contractor assistance or have a system in place for early contractor involvement during the design process. Again, there are ways you can streamline this, contracts you can use to get that involvement, and I think many owners are going to be requiring more of this. For peer reviews, we think peer reviews can go a long way in confirming that design services meet the standard of care and the client expectations. But a peer review must be properly structured. And here are some of the guidance you must follow in developing an internal peer review system or arranging for an outside review of your procedures and deliverables. The peer reviewer's qualifications must be appropriate for that kind of project, right? Not someone who just happens to have the same discipline, but someone who understands the project. There should be a clearly defined scope of what the peer reviewer is going to do, and it should be carried out in a systematic process. It makes sense to have the reviews at least at the conceptual phase and in the final design or report phase, depending on what you're preparing. Conceptual phase, so you can address many of those things early. Final design phase to make sure you're meeting the standard of care and the deliverable obligations. Review, comments, responses, and the resolution of identified issues should be documented because you don't want it discovered that a peer reviewer recommended something and you completely ignored it. And it should have an element of independence. It makes no sense for a professional who is intimately involved in the preparation of the design or design documentation to be in charge of analyzing whether they comply with the contract, meet the legal and code requirements, or are sufficient to meet the standard of care for the professional services performed. And note that many sophisticated clients have requirements for peer review. On some large or prominent projects, the client might have hired its own review firm so that the client can eliminate some of the uncertainty on the project and the time and cost factors that are caused by errors or deficiencies that slip through the process. Also, some clients, often government clients, want to know exactly how you are going to produce a quality project and want regular and final documentation of your procedures and conduct. We also support constructability reviews, and I know that many of you have not used these. It is one of the processes that can reduce a premium or a deductible a firm pays. I think one of the coming developments that will be recognized by clients as a way to reduce the variability in timing, cost, and quality of projects is to have early contractor involvement on design, bid, build projects. There are standard contract documents to support early contractor involvement. I think many knowledgeable clients are looking at ways, in addition to design build, to separate, to really break down the silos of design and construction and incorporate current construction knowledge into the design process. This isn't design delegation where a contractor is asked to provide and certify the design of an element of a project, but rather the seeking of the opinion of a contractor, ideally the contractor with whom the owner is negotiating a construction contract, to help identify how the project can be more efficiently and perhaps more safely constructed. There are many variations of constructability advice or reviews. Often if you get trade contractors or suppliers involved, that can be helpful. Again, early in the process, it makes the understanding better. It gives you time to incorporate construction reviews into the design process. Even if it's just late in the process, even if it's just an evaluation of the construction documents, that can still provide some significant value. This is not value engineering that we're talking about. This is kind of upfront advice that can help you in the design stage, and not a way to cheapen the project, after the construction documents are issued. And remember that we said a learned profession includes continuing education. We try to help. For instance, for over 20 years, we did regional seminars and each year reached 1,000 or more practitioners. And now as a policyholder, you can go to our website for continuing education courses, updates on professional developments, and information that can assist you in moving your practice forward. Our courses can help you stay on top of your risk profile, but of course, you need technically oriented courses as well. And education can assist you in your marketing effort. From a marketing perspective, you want to show that you understand trends and new procedures, products, and industry developments, that you are on top of the profession. But keep in mind that you might need to either add a consultant to quickly educate your staff if a project-specific need is identified. And please realize that just as you need financial advice and insurance advice, you need legal advice. It is a good investment. Often you might have difficulty in finding an attorney aware of both transactional procedures and construction industry legal developments. Go to your local professional society or trade association for recommendations, or even ask us about who defends professionals in your area. Each year we have a continuing education program for attorneys who work with our clients in their defense. Many of them also assist firms with contracts and transaction planning. But whatever you do, do not assume a professional liability insurance broker, your agent, or your insurance company can substitute for jurisdictionally competent legal advice. There are legal constraints. Bar associations do not want the competition of insurance companies or insurance brokers practicing law, And there are practical constraints. There's a major difference between an insurance company providing basic information on the law and the local attorney parsing out contractual language according to how a specific state's statutes and case law affect the contract, or the attorney analyzing a specific situation according to the facts and circumstances that affect the legal status of the parties. So again, find a lawyer who understands what you do and can help you prepare to do it better. So let me leave you with this. Remember communications and use this as your guide. You want to serve your client, and more importantly, you want your client to appreciate your professional skills. Now, for more information, we urge you to visit our website. There it is at the top of that screenshot. On the website, you can find claim studies and firm benchmarking information, practice management information and guidance, contract language and commentary, and of course, continuing education courses that will help you in developing your capacity to manage risk. And with that, now you can take the test necessary for you to receive continuing education for this session. And I thank you for your participation.